now cause number AP 77111, in re Terry Robeson. I'll just say the way we've done this in the past, we'll give you a chance to say whatever you want to say, and then we'll have questions. Or if you don't have anything to say now, we'll just start right in. So would you like to say a few words?
I would like to.
Thank you.
May it please the court. My name is Holly Shulock-Willis, and I represent Terry Robeson in this matter. We are from Wharton County in the 329th Judicial District. This trial ended in February of 2023. The record spans more than 3 years and multiple delays, not all of them made in conjunction with COVID for many other reasons. There have been 2 juries seated in this trial, and the last one had actually 7 days of individual voir dires. So it has been quite the extensive record. Ms. Robeson also has tackled this by herself. The delay actually the last delay resulted in her not being able to call upon her colleagues. She had 2 others on board to help in December of 2022. And because that was delayed until January, they had to go on to their regular job. So one individual has tackled this entire record herself. The record will end up being about 95 volumes or more than 16,000 pages. And to date, she has transcribed and she has also printed 74 of those 95 volumes. She also has kept up with her regular duties as the court reporter for the 329th, and she's done a little pinch hitting over in the 23rd, which we share with an adjoining county when that court reporter was absent due to illness or other matters. We submitted several documents for you. I don't know if you've had a chance to see those today, but one of them is a business records affidavit, and it's about Ms. Robeson's log, her progress report of the work she has undertaken. And when you look at that record, you can see just how diligent she has been to take care of this record in between and many times simultaneously with her other duties. In that same record, you can also see that at the beginning of 2024, and this ties into the second submission that we gave you, is a doctor's note. Ms. Robeson was diagnosed with a health condition that necessitated ongoing treatments. And so since the beginning of this year, she has every week undergone chemotherapy just about every Friday, which has been quite taxing to her. But what you can notice is that 2 months of not being able to work on this record, by March of this year, she picked up the ball and kept running, and so she has made significant progress. The other documents that we sent to you are 3 affidavits from fellow court reporters who have similar experience to Ms. Robeson, and the reason we submitted those was to show the court that it's a 1-to-4 ratio. About 1 hour of work for the court as a court reporter results in about 4 hours of work to transcribe that document. Of course, when there is dense evidence or other technical work that went into it, she's spending extra time on it. So it's about a 1-to-4 ratio. So we believe that she has made significant progress. And then also, I did look at one case related to this to get that definition of contempt. And we believe that Ms. Robeson's behavior does not rise to contempt. She has never been disobedient to the court. She is not disrespectful of the court, and she has no willful intent to not complete this record. She is one person with almost an insurmountable task ahead of her, and she has worked diligently. So at this time, we would ask that the court allow her 6 more weeks to finish this record. She believes that she can. And then after that time, she can begin her healing journey and also still do her job for Wharton County. Thank you.
Thank you, counsel.
May I ask, so are you saying she'll have the record finished in 6 weeks?
That's what she believes, yes.
And to this court?
And to this court.
And so she's willing to abide by that deadline?
Yes, ma'am.
And the word deadline has a definite meaning, right? It's not optional or aspirational, it's an actual hard fixed.
Yes, she's already made plans to forego Christmas celebrations with her family so that she can work solely on this record to finish it. It's also in her best interest health-wise to get it behind her and move forward.
I'm sure that's true.
Yes, ma'am. Thank you.
Any other questions?
I have one. I think you mentioned she's having chemotherapy. Is she still doing that now?
Yes, sir.
Okay, once a week.
Once a week.
I'm familiar with it because my wife went through, a long time of chemo and radiation. So is she able to work the day after chemo?
Well, usually she has those treatments on a Friday, and so she has the weekend to recover, but she will work at home on the record.
Okay, that's all I have.
Anyone else?
I'm just wondering, I'm just looking at my calendar because I'm curious to know if you've put pencil to paper to decide like what date that is, 6 weeks. What is that date? It's two. Which would that be January the 22nd? If that's the date that,
That would be attainable, yes.
Just so you know, we're not mean, but in the future, for future reference, if we know of some of these situations ahead of time, because getting the, I don't want to say excuses, but getting
The reasons.
reasoning at the end makes it harder for us because we're thinking, where is it, where is it, where is it? And we don't know what else is going on. And so we do appreciate that people have other things going on, but I just wanted to say that, yeah.
Absolutely, and it might be something that the court should look at because when it falls to the shoulders of one person in a death penalty case, it truly is almost insurmountable. Even if she had a team working with her, those are a lot of volumes to do, and I'm not sure that maybe the state shouldn't take a look at how we can make this more achievable.
Is Wharton County short of court reporters across
Yes.
the board?
Yes, ma'am.
I have one other question. Say in the last 3 years, has she had other death penalty cases she's had to work on, or just this one?
Just this one, but she has had other murder trials,
Sure.
civil trials, family court, things like that.
Okay, thanks.
And she has achieved them, and she's continued to turn in all of her reports as required.
Okay.
Anyone else? Okay, thank you. If you would remain in the courtroom, we are going to hear one more case, and then we'll take a break, and we'll come back and talk to you when we're through that.
Thank you.
Call now, cause number AP 77113, in re Elizabeth A. Young.
Good morning.
Good morning.
By way of introduction, my name is Steve Dusky. I'm the District Court Judge in the 426 District Court in Bell County, Texas, and I'm also the Admin District Court Judge in Bell County. I'm here, the trial that is the subject of this hearing today. I was the trial court judge. Ms. Young is the court reporter who finished the record, and she's provided, I believe she's provided information to the court that I hope will be responsive to your questions. I'm not here to represent her, but I'm here to answer any questions you may have. As you'll find out from Ms. Young, this is a death penalty case that started in February of 2023 with voir dire, finished voir dire in April of 2023, and then the trial itself lasted and finished in June of 2023. During that time, I believe there were a certain number, 7 court reporters?
Six
Six
total.
court reporters from start to finish, one of which I lost in the middle of the trial by way of an employment decision I had to make. And then thankfully Betty, who's the official court reporter in the 264th, was willing to step in and finish the trial for me. As far as the information regarding questions about court reporting, I'll turn over to Betty to answer. She's more than capable, so.
Thank you.
I had submitted a statement, and on there I broke down the status of the other reporters, and there were 6 reporters, and 1 reporter took all the pre-trials, and she said she can have her part done by January, and then another reporter took 1 day, and they have finished it but didn't submit it to me yet. Another reporter took 1 day, and I haven't heard the status yet, but I'm sure she'll have it done. And then there was 1 reporter that was terminated or let go. She has a bulk of it, all the jury selection, and 2 weeks of the trial. And then another reporter that subbed took 5 days, and she's got 2 more days left to do. And I took the rest of the trial, which was about 3 weeks, and I have about 4 more days to proofread, and I can get that done and then start doing the indexes once I get all the other volumes. There were over 900 exhibits, and it was a lot. I haven't gotten to that point yet because I need to get all the master and all that information from the other reporters. So that's where I stand, and
It's really not clear to me where you stand, or where this record stands.
the record, I'm waiting.
Here's what you say in here repeatedly: you're waiting to hear, you're waiting on a status, you're waiting on that, you're waiting on this. You want to give us another status report. This record was originally due more than a year ago, wasn't it?
Yes,
Okay, and you have how much of it prepared?
for my portion, I have 4 more days. I took 15 days, I think, of the trial.
Okay, the record though consists of 100% of something. How much of that 100% is ready?
I can't say because
Is
I
it-
don't have everybody's,
You don't have anybody's, do you?
no.
Yeah.
No one has submitted anything to me.
Right. Nobody has taken any kind of due date seriously in this case. Not you and not the other court reporters.
I've been working full-time in my other court, taking that docket, and it's been super busy, and I've done the best I could. My husband passed away in April. I had to deal with that.
I'm very sorry about your personal loss, I really am. But what you've submitted to us is a report that says nothing has happened, nothing has been accomplished. And I'm sure you have other duties, and I understand that, and you're working very hard, but this seems to have taken a back seat to everything else. And meanwhile, you just want to give us a status report. Can you give us a date by which you would have this finished?
I really can't say right now because I have to get all of the other volumes from the other reporters in order to do my master index and then deal with all the exhibits that I have to do.
And you can't exert any pressure on them to actually produce these records?
I have tried my best. I email them and say, when will you have it? And this was the latest update that I have.
Do they know that you're here today?
Yes, I told them,
And they know why?
yes, to answer for why it's not done.
And they're not impressed by that, I suppose?
I don't know what to say on that. I'm doing the best I can.
Should we bring them in?
I guess if that's what you need to do. I
Well,
mean,
if we can't get any answers, maybe that's what we should do.
They've given me the status of where they are at, and they say by the end of this January, one reporter said she'll have hers to me. Another one said she'll have hers to me the end of the month.
How long do you think it would take you to get your portion done?
I am almost done with my portion as far as
Right.
my volumes being proofread. Then I have to print them, I have to index them, and then I have to wait on all of the other.
Sure, but just the part that you're able to do, not the other people, how long will you have till you have your part done?
Are you counting the exhibit index and all that, or
I'm
just
talking
mine?
about only the stuff
volumes?
that you is in your
Okay.
personal control.
I intend to have it done in the next 2 weeks, the end of December,
End of
1st
December.
of
So you
January.
can have your portion done by the end of December.
My portion done.
Okay.
Yes, I can get that done. And the problem is, I haven't been able to find subs. There's a shortage of reporters. And even if I take time, I can't leave my court empty. So, and there's only so many hours in the day.
Judge, is there anything that you can do to encourage the other court reporters to help Ms. Young?
Yes, and Betty and I have been having some status updates with the other reporters. The difficulties we have is the other court reporters are not officials in my county. They are, one of them is, who did maybe one day of the record. The others were visiting court reporters or who are not employed there.
Well, I understand that there is a court reporter shortage everywhere,
Yes.
but on these death penalty cases, I know they're big records and they take a lot of work, but what we see fairly regularly and try to avoid is a court reporter who's assigned to a court having to take care of her regular duties while trying to transcribe the death penalty trial. And it often takes bringing somebody in to cover the regular duties to give the court reporter time, the ability to do the rest of the record. And if there's something you can do to help, we would appreciate it.
What I have done to that effect is I was approved through our Commissioners Court to hire a rover so that we would have an additional court reporter, and we've been unable to hire one to this point.
Okay, well, thank you.
But we're still working on that. I have one more interview
Okay,
of somebody who's interested. So we're certainly looking at it from an employment perspective. That appears to be the best way for me to address it, is to hire someone else so that we can address this moving forward.
Have we received a list of the names of those other court reporters?
Yes, they've received notice.
No, but have we received something from your county indicating who those people are?
I think that our clerk's office has
Yes,
that
Okay.
information.
I know they're listed in because the notices from the clerk have included the
Those
other
names
court
as well?
reporters. Not for this hearing, but
Right.
for deadlines, because I've seen that.
Okay, thank you.
Are you in the position to reach out to the other court reporters? I understand her dilemma is that she didn't do everything, but do you have the authority to reach out to the other court reporters within your county, even though they're not from your county, and say, look, these records are due, what's the problem, can we move this along?
Yes,
Okay.
and that's what I've been trying to do.
Okay.
One
don't
thing
know
that
if
really
it's
one thing concerns me is I'm hearing that one of the court reporters has been fired, I guess. Do we know if that court reporter is even working on the case?
I'm advised she is.
Okay. All right. She's the one that would really concern me the most, whether or not that person is diligently working.
So at this point, what would be a realistic due date? Do you have a notion?
I'm not sure if I could just have another status, and then, once I get everybody's volumes in, then if I need to just not be in my court, tell my judge I can't because I have to do this. but we don't have any subs. That's the biggest problem.
Okay, I will mention that status reports are not something this court is used to getting. If a record is due, we get a motion for extension with an explanation about what might be otherwise in status report. But when it's due, it's due. And I don't know what happens in non-death penalty cases or in other kinds of trials, but that is not something that's very helpful, actually, in our court. Any other questions? Judge? All right. Thank you both for coming. Thank you, Judge. Thank you for being here. We're going to take about a 10-minute recess, and if you'll wait, we'll be right back. Thank you.
All rise.
Okay, Ms. Robeson, we are not going to hold you in contempt today. We are going to issue an order later today that will make the record due on February 3rd. And Ms. Young, where'd y'all go? Ms. Young, we are not going to hold you in contempt today either. We are going to issue an order that all the reporters the 6 that are working on this case, plus the part that you're doing of the record, will be due February 3rd. And after February 3rd, you will have 6 weeks to complete the record with the index and the exhibits or whatever else needs to be done. I want to say that these are outliers, and we appreciate you coming in to help us get the record moving. And if you have any questions, let us know. But these orders will issue this afternoon. Thank you very much. You're excused. Call now, cause number PD 058122, PD 058222, Beecher Montgomery versus State of Texas. You may proceed.
Good morning. May it please the court. Matthew Smid from Fort Worth, Texas, representing the appellant Beecher Montgomery. It would really be interesting to see what the founding fathers think about whether the Sixth Amendment right to confront a witness applies at a hearing in which a judge can do anything from dismiss a case to convict someone and then subsequently sentence them to the maximum punishment based on what they hear from the witness stand. It would be interesting. In light of what's at stake, they would hold that it does. They would really be scratching their head if they were to hear that such a hearing could occur when the defendant, his attorney, and the accusing witness are not even in the same room, in a different building. A deferred adjudication hearing revocation hearing is a part of a criminal prosecution.
Counsel?
Yes, sir.
Is all we're deciding here today whether or not the due process requires presence or whether the confrontation clause applies in this? We're not talking about whether the clause was violated, or are we? I mean, that's what I guess I'm stumbling on this, but
Yes,
are we just deciding whether this applies? Or are we deciding not only does it apply, but the due process clause was violated or the confrontation clause was violated?
Yes, sir. Yes, sir.
Which one is it? Is it both of them or is it just one? Just whether it applies?
All of it.
Okay.
Yes,
Okay.
sir. All of the above.
Okay.
Does it apply? Was it violated? Is there harm? Is the harm standard met here? All of it.
So this isn't just a Sixth Amendment claim?
No, well, I think there's a due process tie-in. I think the Sixth Amendment right to confrontation is the focus of this, Your Honor.
The lower court decided also that there was no due process violation,
Yes,
right?
correct.
Would our decision in Hughes, which was based upon due process and a due process violation, would that be something that maybe the lower court should consider before, or they should consider if they're going to reconsider the due process claim?
Yes, sir. Yes, sir. In light of the decision in Hughes, certainly our position.
But there is also a confrontation clause, which is the bulk of what your argument is.
Yes, sir. That's correct. And when we think about it this way, as this court eloquently stated in Taylor v. State, at these deferred adjudications, when a defendant goes on deferred, you hit the pause button, right? It doesn't end the criminal prosecution. It pauses. And then when the petition to adjudicate is filed, the play button is hit. Think of it this way, too. At such a hearing, you could have a petition with 10 allegations. And at this hearing, the defense, prosecution calls witnesses, and the judge says at the end of the hearing, I'm going to find all these allegations not true, and also you know, the defendant actually showed that he's doing a really good job on probation. And in fact, it also came out in this hearing that, I don't know, this offense, it was kind of dumb to begin with. He stole money to feed his family. I'm going to dismiss the case. So there's such a, the court has such authority at these hearings to either dismiss or convict or, and then subsequently sentence up to life in prison.
Is there something that the trial court cannot do? Is there one option that's not on the table after an adjudication hearing? And that's to acquit?
Well, correct, cannot acquit but can dismiss under 42A 111B.
But acquittal is not on the table, do you agree?
Yes, Your Honor, I would agree with that. But can dismiss on the spot. They could dismiss this would be extreme, but they could dismiss 2 seconds into the proceeding. And what further complicates this issue is how a new offense is treated, right? And this court held in Moreno v. State that a new offense, trial for a new offense can go along with a revocation proceeding. They can go at the same time. The court said that's not recommended, right? But the court authorized that. And really, when you think about it, that revocation hearing with the new offense is a part of the prosecution of the new offense. Now, the court said, we don't recommend that. To this day, they do it in Dallas. We don't do that in Fort Worth, all right? But when you really think about it from a practical standpoint, the revocation hearing, the deferred adjudication hearing, is where that's the only chance you're going to get to confront that witness on the new offense.
Why?
From a practical standpoint, the judge is either going to find that allegation not true, and if that's the case, the prosecutor's going to dismiss the case.
Now, wait a minute. As a practical matter, doesn't it depend on what the person's on probation for as opposed to what the new offense is? Whether they proceed first with an adjudication hearing as opposed to proceeding with a jury trial? I mean, if you're on probation for a state jail felony and deferred on that, and you're charged with an aggravated robbery, do you think they're gonna have an adjudication hearing first?
Probably not, but I would think the more, I will represent to the court, it's a scenario where you're on that probation for the first-degree felony. And that's when, or even a second-degree felony like in this case, where you're looking up to life, you're looking up to 20, that's when this new offense is really gonna spearhead the petition. Like in this case it did. A new offense was really the thrust of this. And then if the court finds the allegation not true, odds are the prosecutor, they're gonna get rid of that if it didn't meet the preponderance standard. If the court finds it true and sentences the defendant, in all practical terms, usually how it works is the state either dismisses that new offense because they got what they wanted, they got a prison term, or they're gonna run it CC, is what you'll typically see.
But there's still not a finding of guilt on the newly alleged criminal offense.
Right, but that new offense and witness testimony live witness testimony from the witness stand is what led to the conviction of the revocation case. But yes, you are correct, Your Honor.
Nevertheless, guilt was already established before the adjudication hearing, wasn't it?
Correct, but not a conviction, not a conviction. And the court has full authority to even dismiss the case.
Yes, the court has much discretion.
What's also interesting is this court, time and time again, has applied more rights at these hearings, right? The court has time and time again stepped up for the citizens and given them more rights. For instance, the exclusionary rule applies at these hearings.
What specific instances are you relying on that occurred or may not have occurred in the proceeding that were inadequate to safeguard his rights?
Yes, Your Honor. I would say, number one, lack of contemporaneous communication with defense counsel. He's not able to sit there and exchange notes contemporaneously. As we can all think back to prosecuting days, defense attorney days, you sit down with your client, you throw down the notepad and give them a piece of paper, give them a pen, and they write down things that could be helpful to you. They're the best witness of this event, right? They have the best knowledge. But also, one safeguard that wasn't taking place here is we know the witness is in a completely different room. We don't know if they're by themselves. We don't know if they have access to a cell phone. We don't know. They could be reading from a teleprompter. We have no idea. That safeguard, there was nothing to safeguard from that. We just know they're in a different room. We don't even know if they're by themselves in the room. There were several instances in the hearing, and my friend, in his brief, has a reply to each instance. But when we think about it this way, and it was a mess, but don't take my word for it. Take the judge's word for it. He says, remind me, we're never doing this again. Okay? Judge Gallagher's fantastic trial judge in Fort Worth, he tells it like it is. He knew it was a mistake. Because throughout...
Counsel,
yes, sir.
Is your argument dependent upon this being a deferred adjudication, or do you think that whatever we would announce today would apply both to a deferred adjudication proceeding or a probation revocation as well?
Excellent question. Both.
Thanks, I thought so.
Both. Even more so for a deferred.
Okay.
Even more so.
Okay.
Yes, sir. Yes, sir. Back to Judge Hervey's question. Several instances in the hearing, you have the judge disappearing, defense disappearing. You have an instance where a witness is testifying, and she's asked to identify the defendant. She says, well, I don't see him anywhere up here. Oh, you got to scroll over after she's already testified into the hearing. So who knows how long that's been happening with each witness? We don't know. You have...
Can't ask questions of the witnesses, you know. We'll go back to the cell phone. You can't ask them if there's somebody else in the room or if they have a cell phone. You can't ask them that.
No, you certainly can. You certainly can. But we just don't know. There's nothing to safeguard that person is by themselves, not using anything else.
Well, if you're asking them the questions, that's a safeguard. The defense attorney could ask.
No, that's correct. That's correct. And in fact, in one instance, you even have a disturbance at the jail. There's some kind of fight or disturbance, and the judge said, what's going on back there? And Mr. Montgomery says, there's something's going on behind me, Judge. I don't know. Okay, well, maybe it's quieted down. Let's keep going. They don't go back and redo whatever they were doing. We don't have that. And also, what's interesting too, in a Zoom, we've all been on Zoom, you have a box with someone's head in it. We don't see their hands. We don't see whether they're fidgeting. We don't see whether they're shaking. That's an important part of cross-examination, right? A big question I know that weighs heavy in the court's mind too is, well, what about the feds, right? The feds say you don't have to have this. It's different. It's a different animal. The federal judge, he's got a lot of power. He doesn't have the power at this revocation hearing to dismiss the case. He's not deciding whether to convict the defendant. That's not what's at stake at the federal hearing. Also, interestingly enough, federal probation is so exclusive. It's rare. And don't take my word for it, the United States Sentencing Commission has these statistics out there. In the Northern District, Southern District, Eastern District, Western District, of all the sentences in 2023, 3% were probated. The
But
guidelines.
what is it that's different, though? I mean, sure it's rare, but what's the difference between the way that proceeding goes in federal court and the way that it goes in state court?
Yes, sir. Is the defendant going to be convicted? And we're talking about live testimony. This trial judge is basing his decision whether the defendant is going to be convicted from live testimony from the stand. And there's also an interesting sentencing tie-in too here. That's the other part of this equation, because immediately after the hearing, you're going to have a sentencing hearing where the full range of punishment is on the table, right? And here comes another federal comparison, right? The feds say confrontation clause doesn't apply at sentencing. But federal sentencing is a different animal. The PSR drives that sentencing. And I always tell my clients, for lack of better judgment, I practice a lot in federal court, and I tell my clients, the battle's done before we step in there for the hearing. We put in our work, and what the sentence is going to be determined before we go in there, because we sit down with the officer who's writing the PSR. We meet with her. I'm able to meet with him or her before the PSR is drafted and provide information, right? And if I don't like what's in the PSR, Federal Code of Criminal Procedure allows me to object to that in writing. And I can subpoena people to the hearing based on what I hear, or based on what I don't like in the PSR. Compare that to a case like this where there is no PSR. Everything is happening from live testimony on the stand, right?
But why is it that if they can do that in the federal system, they can't do that in state court?
Because in state court, in a non-PSR case, it's all coming from the witness stand.
Okay.
I don't have that PSR. And my friend brings up a good point. When we talk about whether sentencing confrontation applies at sentencing, I cite to the Russo case, right, which is a non-PSR case. And that's where statements from jail records were confrontation clause violations. And then my friend cites to Stringer. And I think there's a big difference between Stringer and Russo. Stringer is a PSR case. Same thing. Yes, go along with the feds there. You got the full PSR process where we can go through that. But in Russo, no PSR. The bullets are flying live at that confrontation, live at the sentencing hearing, right? I also think, too, this court applies the exclusionary rule, as we found out in Morey State. And let's say there's a new offense where an officer just goes into someone's house and takes a bunch of drugs without a warrant exception. This court says at the trial court hearing, or at the deferred adjudication revocation hearing, judge, throw that out. That's a violation of the Fourth Amendment. Now, my friend will say, hold on, counsel, that's a state statute. That's 3823. But my response to that is it's rooted in the Constitution. It's a Fourth Amendment violation. This court basically says if you violate the Fourth Amendment, that cannot be considered in the revocation hearing. Same thing with the Fifth Amendment. If there's a Miranda violation where a new offense is based on a confession, based on a Miranda violation, this court says Fifth Amendment applies, right? Fourth Amendment applies, Fifth Amendment applies, and Shivers, ex parte Shivers, this court said these deferred adjudication hearings, they are a critical stage of the criminal prosecution. Critical stage. Sixth Amendment applies there. Hughes, due process applies. We've applied all the Constitution. Let's not just leave one part of it out. We respectfully request that you apply the entire Constitution, as this court has gone above and beyond to do already. Also, Brady versus Maryland applies, right? 3914 applies. The Texas rules of evidence apply, and that goes hand in hand with the Constitution. Obviously, the Constitution trumps the rules of evidence. I get that, they're more important. But the rules of evidence were drafted with the Constitution in mind. You can appeal the court's finding of true. Baker v. State, this court has said. In other words, if a judge finds the allegation true, I can appeal the sufficiency of that. That's sounding an awful lot like a criminal prosecution.
Have you invoked in any way the Texas Constitution as part of your argument, or is it limited, is our discussion of this limited to the federal constitutional rights that the defendant might have?
Excellent question. I believe that was invoked at the trial court level. And of course, when it comes to confrontation, Article 10 in the Texas Constitution and the Sixth Amendment, they mirror each other. They are one and the same, we feel. But that was preserved at the trial court level, I believe.
Was that part of the lower court's decision, though?
I don't believe so, Your Honor. I believe so.
Did you reserve some of your time for rebuttal?
I did, Your Honor. 3 minutes.
Thank you, counsel.
Thank you so much.
May it please the court, good morning. My name is David Richards. I'm an assistant criminal district attorney in the Appellate Division of the Tarrant County DA's office. It's been 13 years since I've appeared before this court. It's good to be here. Judges, there is much confusion in Texas appellate courts between the Sixth Amendment right to confrontation and the 14th Amendment right to due process. The question before this court is whether at a deferred adjudication revocation hearing, and Mr. Smid says it's also, in response to your question, Judge, it's also dealing with regular straight probation revocations. So if that's the case, then there's even more confusion, because I thought that matter was settled. The question that discretionary review was granted on was whether or not the Sixth Amendment right to confrontation applies at deferred adjudication revocation hearings. Now, it's an interesting question because there are overlapping protections of the Sixth Amendment confrontation and the due process clause of the 14th Amendment. And that is what the Hughes case, where this court said, you know, the 14th Court of Appeals misapplied the Sixth Amendment. They got the test wrong there. But you know what? We say that there's a due process violation, a 14th Amendment violation, even though we agree with the state that there was not a Sixth Amendment violation. So it is confusing, but I suggest that the United States Supreme Court has dictated the result in this case. And I want to briefly, I'm not going to read a lot of the opinion, but in Betterman versus Montana, 2016, United States Supreme Court opinion, I want to read one sentence from that court and particularly pay attention to the last part of this sentence. We hold that the guarantee, they're talking about the Sixth Amendment here, protects the accused from arrest or indictment through trial, but does not apply once a defendant has been found guilty at trial or has pleaded guilty to the criminal charges. In this case, Beecher Montgomery, although he was placed on deferred adjudication probation, he pled guilty to the criminal charges. The criminal charges in this case were a theft, felony theft because of some repeat offender.
Would it be different if he had pled no contest?
No, wouldn't be
Why not?
different, because that would be the equivalent of a guilty plea. So there is no distinction there, and I don't believe, no court has ever drawn that distinction. And would also point out that although the appellant claims this is a close issue controlled by the U.S. Constitution, not only has every federal Court of Appeals ruled against the defendants on these issues, including the Ninth Circuit, by the way, but every state court in the entire country, with the exception of Arkansas, has declined to accept the argument advanced by the appellant. And in that case, if you take a look at it, and I noted in the brief, the appellate court there was, I think, the 4th District Court of Appeals in Arkansas, didn't actually say the Sixth Amendment applies. There is an Arkansas statute that the court relied on. The court says, basically, right to due process, right to due process. They're talking about the 14th Amendment, and then they say, by the way, we have an Arkansas statute that gives the defendant the right to confrontation, but it's a limited right to, it's a conditional right to confrontation. You do the balancing test. How bad does he need to confront the witnesses versus what are the circumstances? In our case, that circumstance would, of course, be COVID. And we had the hearing, the Zoom hearing, because of COVID. So under the Arkansas Court of Appeals opinion and under the Arkansas state statute, that actually goes with the state. So there really is no state in the country that supports the argument advanced by Mr. Montgomery. Now, what's the reason that they say Arkansas goes against the Sixth Amendment, the rule that the Sixth Amendment doesn't apply? And that's because It's a rare instance where West Publishing Company made a mistake. If you go to Head Note 2, under Goforth versus State, West says it's a Sixth Amendment. It's a holding under the Sixth Amendment. No, it was a holding under an Arkansas statute and the Due Process Clause of the 14th Amendment. Once they issued that opinion in Goforth, other Arkansas courts picked up on that and mirrored the holding. But Goforth is really not an opinion that the appellant can rely on. Now, what is the underlying reason the United States Supreme Court in the Betterman case said that once the defendant pleads guilty, and the state contends that's the key, Mr. Montgomery pled guilty to the underlying charges. What's the rationale for saying that the Sixth Amendment claim is extinguished at that point? Well, I think we need to stop, and it's easy to lose the forest because we're so close to the trees. So if we take a couple of steps back and realize the whole point of our criminal justice system, including the reason that this court exists, is to ensure as best we can that we don't convict factually innocent people. Now that concern disappears when the defendant pleads guilty. In this case, Mr. Montgomery pled guilty to the theft and the fleeing with the motor vehicle. Now, he didn't plead guilty to the charges, the revocation charges, but he did plead guilty to the underlying charge. That's what controls. That's what the United States Supreme Court says controls. So if you follow, and you're actually required to, because the U.S. Supreme Court, the same year, 2016, that the Betterman case was handed down, said, you know, state courts, they're free to formulate their own rules under their own law, but they can't tinker with the federal Constitution. They can't experiment, I think is the word that they use, with the federal Constitution. So we'd ask that this court follow Betterman versus Montana, which we believe the court is actually required to do. Now, the question, Judge, on Hughes, whether or not the Court of Appeals discussed the claimed 14th Amendment violation. Yes, they did. And they went through all of the arguments that we heard from Mr. Smid, and they said, no, there's no violation of the 14th Amendment. In Hughes, you'll recall this court was faced with a situation where the defendant was brought in and the trial court muted the defendant during the hearing. And you couldn't tell from the hearing, from the transcript, and neither party had a good answer for you during the oral presentation of whether or not, in fact, he ever became unmuted. Apparently he did at times. You couldn't tell where his mic was unmuted and where it was muted. He claimed he didn't have the right to confer with his counsel because his counsel was present in the courtroom and he wasn't. He was, his image and the audio was being piped in from the jail across the street. This court held because of that, the 14th Court of Appeals erred in applying the 6th Amendment, but the 14th Amendment, due process, required reversal of that conviction. Now, there were some disagreement among members of the court as to whether the error was preserved and this and
Right.
that.
Actually, I wanted to clarify. I don't remember Hughes saying they erred in saying the Sixth Amendment applied. It was more that the argument that was raised was a due process argument, and they shouldn't have couched it in terms of a Sixth Amendment,
Yes.
not necessarily that answering the question.
Well, they in Hughes, and I could be wrong, but I think in Hughes, the argument that the 14th Court considered was a due process type claim.
Right.
But then at the end, they concluded, therefore, because he was denied due process, Sixth Amendment
Sixth
violation.
Amendment, and, right.
And this court said, no.
Yeah,
It's
so
due
the-
process. There
I
are,
guess I just wanted to be clear, because that's what I understood as well, is that it's not so much that they answered the question about whether the confrontation clause of the Sixth Amendment applied or didn't apply. It's that we took issue with the Court of Appeals mixing the two concepts together, and we decided entirely on due process, leaving open
right.
the Sixth Amendment
And
issue.
I thought your question was a good one, whether or not the
I thought so
Court of
too.
Appeals, well, again, that's what was your answer before to him. That was the decision in Hughes. This case should not be remanded to the
Okay.
second court for reconsideration under Hughes, because in effect, they kind of did, although of course not Hughes per se, but there were a number of these arguments made both in the trial court and in the Court of Appeals that the 14th Amendment due process right was violated because of these, I call them glitches, that occurred during the hearing, and there were glitches. And yes, Judge Gallagher was frustrated and said, remind me never to do this again. It was a very long hearing, and as one of the cases, our intermediate court said in the brief, that frustration is kind of goes with the times as far as Zoom hearings go. But unlike the court in Hughes, if you compare what the trial court did in Hughes in muting the defendant and then making things very confusing, Judge Gallagher got every single issue that was a problem, potential 14th Amendment problem, straightened out in the trial court.
So these were minor glitches?
They were very minor glitches. And I'll point out, this is kind of an interesting, this did occur during the COVID crisis, but the written objection, if you take a look at the long written objection that the appellant filed in the trial court, here's what the appellant said. I object to this hearing, revocation hearing, being conducted via Zoom because I don't have the right to confront the witnesses and talk to my attorney and do the kind of things that Mr. Smid said clients and attorneys need to do in confronting the witnesses. Then in the written motion, the defendant says, but you can't bring me over to the courthouse because if you bring me over to the courthouse, I'll have to sit 6 feet away from my attorney and I won't be able to confer with him, doing the kind of things Mr. Smith talked about, the kind of on the spot, on the moment discussion that we can have about how to cross-examine the witnesses. Then the defendant said, finally, and you can't postpone the hearing because that would deny my Sixth Amendment privilege to a speedy trial. So what was the trial court supposed to do? We couldn't have a Zoom hearing, we couldn't have a hearing in court, and we couldn't postpone the hearing because all of those would be a violation of some clause within the Sixth Amendment. And that's simple. I mean, I don't know what Judge Gallagher was supposed to do in that situation. Now, the Sixth Amendment, stepping back, the Sixth Amendment has 5 clauses. The right to a speedy trial, the right to an impartial jury, right to confront witnesses against him, right to have assistance of counsel. All of those clauses are dependent on the phrase, in all criminal prosecutions. And the United States Supreme Court has repeatedly said probation hearings do not constitute criminal prosecutions. So if they don't constitute criminal prosecutions, then things like the right to confront witnesses doesn't apply. Now, Mr. Smith says, but it's only fair that these clauses kick in because really revocation hearings, particularly deferred adjudication hearings, should be considered criminal prosecutions because the defendant hasn't been sentenced yet. Well, under Betterman, number one, it doesn't matter. It was the fact that he pled guilty to the original plea that means that the Sixth Amendment doesn't apply. But if he is correct, assuming that he's correct, and all of these clauses do apply, because it does constitute a criminal prosecution, what do you say to a defendant says, where's my jury? I've got a right to trial by jury under the Sixth Amendment in all criminal prosecutions, and if it's confrontation is included, where's the jury? And of course, we can't do that. Both the United States Supreme Court and and I believe even this court has said, look, there are all kinds of situations, and there are all kinds of, in the case that Mr. Smid says, there are all types of procedures and outcomes and different things that a trial court can do in a deferred adjudication hearing that he can't do in a regular probation hearing. But if you note all of those things that the judge has at their discretion, all occur in the decision-making process at the end. The witnesses by that time have already testified. Now, Mr. Montgomery, for example, he was originally on trial, or going to be on trial. He waived his right to trial and got a deferred adjudication for the fleeing a motor vehicle and a theft. But he was charged, among other things, on his probation violations with going into his mother's house, picking up his mother and throwing her to the floor. And she was there at the hearing, and he even greeted her on the record. Well, in that situation, he had no Sixth Amendment claim because he'd already pled guilty to the two charged offenses. Now, it may be the case that Mr. Smid is correct, and I don't know the statistics, but it may be the case that yes, in most cases, the fact that the defendant, say, on probation for felony theft, picks up an aggravated robbery, he could be sentenced for the theft and not prosecuted for the robbery, but he could be prosecuted for it. There's no Fifth Amendment violation there. He can be prosecuted for both. So the idea that everything about a deferred adjudication revocation hearing, every aspect of the United States Constitution applies isn't true.
Counsel, let me ask you a question. Pretend that the only allegation in the motion to adjudicate was, like you mentioned, throwing the mother on the floor or whatever. Mm-hmm. And if the judge found that not true, then assuming that the motion to adjudicate, the language tracked exactly the indictment or the information, I don't know if it's a felony or misdemeanor, depends on the issue, but let's say it tracked the language exactly. The fact that if the judge found that allegation to be not true, you could not subsequently prosecute him for the assault. Doesn't that somewhat lend some credence to counsel's argument that, look, this is a criminal prosecution? Because I have a chance basically to get acquitted of this other offense in that situation.
It doesn't constitute a criminal prosecution because the United States Supreme Court said it doesn't. Now, there was some question of, well, what about the Texas Constitution? Is it possible that Article 1, Section 10, which is the confrontation clause, might apply in that type of situation? And actually, there also is a due process of law protection under the Texas Constitution different. It's Article 1, Section 18. They call it due course of law and not due process, but you have to assume it's the same thing, and that is not before this court. But this court would be free if they wanted to. If you wanted to address whether or not the Texas Constitution provides a defendant more protections than the United States Constitution, that's one thing. But That was not raised, I don't believe, in the Second Court of Appeals. And I know there are cases out there saying if they don't specifically raise on appeal a claim under the Texas Constitution and differentiate why it's different than my time is up.
Mr. Richards, I want to ask you a question. How long have you been in the appellate section?
I did a stint as a judge on the Second Court of Appeals. I ran for this court unsuccessfully way back in the day. I was a defense attorney for a long time. In 2015, I rejoined the DA's office in the appellate division.
So have you had the opportunity to try to cross-examine someone by Zoom?
No, but I can tell you, I have had the required duty of participating in Zoom hearing, and it's very difficult for me. Now, I can tell you just, and I'll answer this very quickly, I know my time is up. Judge Gallagher bent over backwards here. Every time the defendant wanted to talk to his attorney, Judge Gallagher allowed them to talk via a chat room, a breakout room, I think it was called at one point, a chat room in another. So, yes, Judge Gallagher, like me, is a baby boomer, and baby boomers have very difficulty.
The problem that I'm getting at has nothing to do with actually being able to talk to your attorney and things like that. The problem I'm thinking about is there's good cross-examiners and then there's bad ones. You know, and you've had a lot of opportunity cross-examining people. And wouldn't you agree with me that even if you're great at it, you're not going to be really good doing it on Zoom?
Initially, I don't think I would be, and in part that I think it is a question of getting used to Zoom technology now. And I'll admit, Zoom technology, you run the risk under the 14th Amendment. If you've got a revocation hearing, not in person, but you're doing it by Zoom, you could run into the same kind of problems you ran into in the Hughes case. And yeah, you're taking a risk by having that type of hearing. But I think as Zoom technology gets better, and who knows, eventually we might be able to have the clarity of the proceedings and have the technology down to the point where it isn't that risky anymore.
But even if the technology's great, you can't really do what you want to do on cross-examination over a computer screen, can you? You really can't. If
now,
you're good,
right now
you
you're,
really can't do
right,
what
right
you
now
do.
you can't. But that is, if you can't, you're talking about a due process violation under the 14th Amendment. You're not talking about a Sixth Amendment claim, because the Sixth Amendment claim under Betterman was extinguished when the defendant pled guilty. The revocation hearing doesn't concern the Sixth Amendment. It's due process under the 14th Amendment. And yes, you're running the kind of risk, and yes, I would prefer to cross-examine a person in person, in court.
Thank you, Counsel.
Thank you.
Please court. The inability to contemporaneously communicate with your lawyer, for your lawyer to effectively do his job, in effect, is more than a minor glitch. The inability to have face-to-face confrontation and to witness it, a witness's demeanor and how they actually look like in person, as the court demonstrated in this recent opinion of Finley, is more than a minor glitch, okay? And I understand, in a business setting, when you have a Zoom and you're talking about accounts receivables and business functions, yeah, minor glitches happen and we get through that. But when we're talking about a guy's liberty at stake, when we're talking about someone who's going to be convicted.
How do you answer Mr. Richards' point that the Sixth Amendment right to confrontation was extinguished at the plea?
Again, to the federal comparison, that's a federal case. We have a unique system here because he was not found guilty. And the other problem is, Your Honor, we have the sentencing to deal with here too. There's a sentencing tie-in where we have to deal with this issue of is it extinguished at sentencing as well? Because that would be in conflict with this court's opinion in Russo, right? So that's an issue as well. And also, when we're talking about other jurisdictions like Arkansas and the other states, we're different here. This is unique, and that's what's special about deferred here. 42A 11B, giving the judge the ability to dismiss this thing 2 seconds into it. Fourth Amendment applying, the Fifth Amendment applying to the exclusionary rule. 3914, Brady versus Maryland, the right to appeal, the rules of evidence, it's all on the table at these hearings, and that's what makes it different than these other states. That's what makes it different than the federal system. It's my understanding, the Texas Criminal Defense Lawyers Association filed an amicus brief last night, and they point out the importance of cross-examination. They cite Professor Posner, who reminds us that cross-examination, it's the lifeblood of our American justice system. It is the true vehicle in determining whether someone is telling the truth or not. And when someone is facing a final conviction, and when someone is then facing possibly up to life in prison, I know our founding fathers, we know they would want it to apply. But unless anyone else has any more questions, I really appreciate the time.
I do, Mr. Smith.
Yes, sir.
You know, I appreciate your passion. Could you do that over a computer screen as well as you've done it here today?
No, sir, and I wouldn't be able to use my height advantage either. That's kind of the one thing I have. Right? So, no, it would be a big problem, Your Honor.
Okay,
Yes, sir.
thank you.
Any other questions?
Thank
Thank you, Counselor. The case is submitted.
Yes, thank you for your time. Thank you.
Call now cause number PDO 37724, PDO 37824, the state of Texas versus ERIK Rodriguez.
May it please the court, Presiding Judge Keller. I've brought 3 points of error in this case.
Would you state your name on the record,
I
please?
apologize. Nathan Morey for the state of Texas and Bexar County. This is a state's appeal for which I've brought 3 grounds for review. I'm going to talk primarily about the first one, and I hope to address the third one. I'm going to let, unless the court has any questions, I'm going to let the second one, I'm going to rest on the brief. As to the first point of error, this court has talked about the standard of review in suppression cases many times, and it has used lots of words like bifurcated, it's used words like deference, and words like discretion. And I think this case illustrates how a court of appeals can quickly fall into a habit of going to discretion when it really needs to use the bifurcated standard. The bifurcated standard is where the court must defer to the trial court's findings of fact, but then review the legal conclusion de novo. I don't like to use the word discretion when I'm talking about the bifurcated standard, and I believe it really has no place in that standard. I think discretion is better left to reviewing the numerous evidentiary rulings that any trial judge would make during the course of a jury trial, because we know if 100 rulings are made, this court certainly can't review each one of those de novo. That would be inappropriate. So this court and the Supreme Court have come up with a zone of reasonable disagreement standard that is a necessary tool for reviewing those sorts of cases. But in this case, which involved a Fourth Amendment seizure of a police officer's cell phone, the Court of Appeals used a reasonable disagreement standard when reviewing a Fourth Amendment question. The Supreme
Was his cell
Court,
phone his personal cell phone or his work cell phone?
I believe it was his personal cell phone. The Supreme Court and this court have both held that ultimately the question in a Fourth Amendment ruling, the ultimate question is subject to de novo review. That's to say that there is no more reasonable disagreement that judges may have when one, if you have a courthouse like Bexar County, I've got 10 district court judges, and there is a zone of reasonable disagreement amongst those 10 judges. I know I'm going to get different rulings depending on which court I go into. But when it's a Fourth Amendment claim, theoretically, there is only one result. And that question is whether the police officer at the time who did the search or seizure, whether that officer was objectively reasonable. Once that officer is objectively reasonable, you can have any disagreement you want, but the officer's objective reasonableness controls and whether that is a legal search or seizure. And in this case,
And again, this is looking at whatever facts led to that in the light most favorable to whatever the trial court
correct.
ruled. Yeah.
And in this case, I would note, finding 47, the judge, there was essentially one witness. There were a few witnesses that talked about extracting from the phone, but I don't think those witnesses are pertinent to the grounds raised for review. There was really only one witness who offered pertinent testimony, and that was Detective Aisha Jackson. And in finding 47, the trial court found her credible. This really was not a case where there was a disagreement on the facts. I think everybody agreed what the facts were. She had investigated a possible leak of police department information to a family violence suspect. She came to a conclusion after searching the suspect's cell phone that suspect had communicated with the defendant, in this case, Officer ERIK Rodriguez. She found the number in the family violence suspect's phone. She did some investigation as to their possible connection, and she looked at the department records, and the same cell phone number, only one number appeared. It was his personal cell phone. So at that point, she had probable cause to believe that ERIK Rodriguez had given information to a suspect that was confidential and that he did it for remuneration. And so she did seek a warrant, and we conceded at the suppression hearing that the warrant lacked probable cause within the affidavit, although she did possess the facts that established probable cause at the time. She approached Officer Rodriguez at roll call. When she approached him, she saw him holding his cell phone in his hand. It reminds me of, there's a Supreme Court case, I think Riley, where the Chief Justice writes how you would think our phones are attached to our hands because they're such an integral part of our lives.
Which is why she got a warrant in light of Brown.
She got a warrant. But it was, and we conceded that the warrant lacked probable cause. But at the time, she knew what she wanted. She wanted his cell phone. She wanted his personal cell phone. She had reason to believe there was evidence that he had committed a crime, and it was on his personal cell phone. She saw him holding it. She was in a place where she was lawfully positioned to take possession of the cell phone without trespassing. So she met the requirements of the plain view doctrine, even though she did not, I will admit, she did not subjectively intend to seize the phone.
What about the fact that she said she believed she had a valid warrant, not because she saw it in plain view?
So her subjective intent was that she was seizing it pursuant to the warrant, if that's your question, Judge Herbie.
Yeah.
So subjectively, she had sought a warrant. Subjectively, she wanted to seize the phone, but subjectively, she wanted to seize the phone because she had the warrant. Now, she also believed that that phone had evidence of a crime in it, and it was in plain view.
Hence the warrant.
Hence the warrant, but also hence she took it from his possession without committing any trespass. And I do want to stress, the state is not advocating that the plain view doctrine will authorize the search of the contents of a cell phone. It merely authorizes the seizure of a cell phone when police have probable cause to believe a crime has been committed, when it is immediately apparent that the phone contains evidence of the crime, and when the police are lawfully positioned to take possession of the phone without a trespass. And in this case, once those facts are established, it simply becomes a question of Fourth Amendment law. Ultimately, were the actions of Detective Jackson, were they reasonable under the Fourth Amendment?
Specifically, though, this isn't going to be a situation where you're going to have a police officer on a roadside, hey, I can seize this phone in plain view. They have to know something about what's on the phone.
Correct.
Before they would do it, which is her seizing it was based on her knowledge of what was in the phone.
Correct. Yeah, they would have to, I mean, I think one of the things that was at issue with the trial court is to what threshold does the immediate apparent have to be? And one thing I guess I want to stress is.
This isn't moving things to find serial numbers.
Correct, no.
This isn't the golf clubs and
the moment she saw it in his hand, that immediate apparent was there because she had already looked at the phone from his friend.
Mm-hmm.
She had already done the research as to who his friend was talking to, and she had established their relationship and I think maybe like a Cash App transaction.
So the connection was, she's looking at the phone of a friend that happens to have the suspect's number in that phone.
Correct. I believe that there was a SAPD investigation into a domestic violence incident. Then there was a subsequent incident, and at that time, I believe the victim of that crime had made a statement that caused police to suspect that someone inside the department had leaked information to the perpetrator. And at that point, I believe the record shows she got a search warrant for the perpetrator's phone, and that she had already seen the contents of his phone, which was basically the basis of probable cause.
So her knowledge, though, is there anything to be made about the fact that her knowledge of what's on the phone was before the seizure at some point, that there might have been a delay or something like that? Right? She has knowledge of what's on the phone, and that's where she gets the warrant.
Right.
And she executes the warrant later to get the phone. Does the time delay between those two things make any difference?
No, I think everything occurred within a fairly short period of time. I think the Fourth Amendment requires, there's a timeliness element because you want to know that what you're looking for is in the place you're searching, and I don't think that's an issue.
Are we talking two warrants, one of the perpetrator and one of the officer? So the original phone that the officer's looking at, she has a valid warrant, gets into it, sees the information, and then from that surmises that the police officer's involved. Is that how it goes?
So Judge Richardson, I believe there are actually 3 warrants, only 2 of which are at issue.
Okay.
Or really only 1 of which is at issue. The first warrant is not, I don't even believe the affidavit's in the record. It is to search the cell phone of an individual who's not on trial, or at least he's not on trial in this case. Okay. And there's no standing to challenge that warrant, and that warrant was never discussed. I believe it's just referred to in her testimony. The second warrant is the initial warrant she applied to the Bexar County magistrate to get the defendant's cell phone. I believe it is styled a search and seizure warrant. I believe she said she believed it was only to seize. That was her subjective belief. But again, the state conceded probable cause was absent on that affidavit, so that warrant's really not even at issue. And then the third warrant was signed by a district court judge in Bexar County, and that was to search the contents of the phone for evidence, if that answers your question. So the question, her subjective intent as to why she was seizing the phone or what her authority to do it is ultimately irrelevant to whether the seizure is objectively reasonable. What makes it objectively reasonable is she had probable cause that a crime was committed. She could visually see the object that had immediately apparent evidentiary value, and she took possession of it like any good officer should do in that sort of situation.
In making that determination, is it, are you taking the position that it's a mixed question of law and fact, or has it moved all the way into simply a question of law?
I think at this juncture, we are in just a pure question of law. This is a de novo review of a Fourth Amendment seizure. Detective Jackson was found credible, and nowhere in the trial court's findings of fact, nor really in the Court of Appeals opinion, does anybody take issue with the historical facts that transpired in this case. She saw a person holding a cell phone that she believed had evidence of a crime on it, and she took possession of it.
You have to take into account those other things that she was aware of before she went into the point where she got the phone.
Correct. She has to have, I think, this court had a case called State v. Duran that involved a car swerving over a line. and it was captured on video camera, but the trial court found that the officer was not conscious of the lane change at the time he did the traffic stop. And I think what this court said is the police officer has to be aware of the facts, regardless of what their subjective intent is regarding the facts. They do have to be consciously aware of them. And she was in this case. She had already looked at the other suspect's phone, and she had
Is she
done
the author of the affidavit for the warrant?
both affidavits,
Yeah,
yes.
so we can see what she knew from what she swore to.
Correct.
Yeah.
Correct. And I want to address one other thing regarding the phone, and maybe try to get to Article 180125. And that is the fact that he could have two cell phones, I don't believe renders this a bad seizure. It still renders it a reasonable seizure. The Fourth Amendment does allow for police to search things that ultimately bear no fruit, or to arrest people who may ultimately be innocent, so long as they're being reasonable when they take those actions. Regarding,
Going back to Judge Urey's question, so I'm concerned about, is there some kind of time lapse between the learning information from appellant's girlfriend, getting the warrant, and then approaching the appellant while he was on duty? I mean, so.
I don't know the exact timeline in my head as I stand here before you, Judge Hervey. I believe that the family violence suspect's girlfriend had made a complaint that led police to believe that the suspect in that case had received information, at which time they got a warrant for the family violence suspect's phone, not the defendant's phone in this case. I think this all happened within, a matter of days. But by the time they took ERIK Rodriguez's phone at roll call, they had already searched the phone of Jeremiah Gonzalez, I believe is his name. His phone had already been searched, and if you look at, there's a confession or an admission recorded. It is clear in that she has already talked to Jeremiah Gonzalez and looked at his phone. If you look at the context of that admission, and that takes place within an hour, maybe even minutes of the initial seizure of the phone in this case. She had already taken it into her possession. Does that answer your question, Judge Hervey? I'm going to, in the brief amount of time, talk about Article 18. Article 1802 allows police to search cell phones with search warrants, subject to Article 180215. By its text, Article 180215 refers to phones that are seized pursuant to a lawful arrest. In this case, this phone was seized outside of the context of an arrest. I'll talk more about this when I have rebuttal, but that is crucial. Article 180215 does not apply to this case, as the trial court has made findings of fact. And I will reserve the remainder of my time for rebuttal.
Thank you, Counselor.
Good morning. May it please the court, counsel, if the court will indulge me for 1 minute. I understand this is your last submission this year. So by day, not date, it's 35 years to the day when I first appeared in front of this court in ex parte BEECHER. I've appeared in front of you several times, and thank you all for service in my career. The overall question that I've seen in what counsel says today, what's in the opinion, in the dissent below, is the reasonableness of the action of Officer Jackson at the time. In the dissent below, they kind of said, or specifically said, oh, she could seize any cell phone he had. Well, I'm not sure what the basis is, because they've already admitted, and the state abandoned the first warrant in the trial court, and that's at page 4 in the Court of Appeals opinion. So what we're there on is either plain view or consent, or she can't take that phone. the question of her credibility and what the trial court found and what is reasonable does not go to her intent getting there. It's what happened when she showed up with her supervisor and took the phone from the defendant. And what I understand is she asked him, is that your personal phone? It's off. If you were to ask me, is that my personal phone, and disregarding the personal property aspect of it, is that my personal phone? Yes, it is. That one's off too. But were you to ask me, is that my personal phone, I would say yes, right? It's also my business phone, but it's a personal phone. It has 2 lines.
How many more do you have?
None to, no, but I have carried 2 phones, actually since I began working with Mr. Jasuta, because we have our business, my business, and another business. But I think the point is, all we have to do to change the identity of the phone is switch the SIM. And her question was, is that your personal phone? And that was obviously, as set out in the opinion, based on the fact he had a personal phone number recorded with the police department. And I will tell you, it wouldn't take me more than 2 minutes to make this phone, that phone, and vice versa, because they didn't know it was his personal phone. All they knew is his personal cell number was the same one they called Mr.
Well,
Gonzalez.
even without the swapping out SIM cards, though, asking the question, is that your personal phone? Is that all she had? Does that damage the question of whether it's immediately apparent it's the phone that she has information about?
Yes, but that wasn't asked.
Okay.
The question is that your personal phone? Yes. Well, I have a warrant. You have to give it to me. Now, as I believe it's your question, but as counsel has admitted, to get in plain view, they must know something about the phone. Is that the phone on which the calls were made? And if we're talking about probable cause, then we have to probably believe, or believe that that phone, to rephrase, to reasonably believe that that phone will probably reveal evidence of the crime they're investigating. Not possible. All the police knew was he had this number, and that number was called. He had a cell phone in his hand. Is that your personal cell phone? She took it. Now, to say that that's a reasonable belief that they will probably find the evidence of the criminality on there is not reasonable. And it is interesting to me that the first ground for review is that the Court of Appeals failed to follow Guzman. And yet, as I read the Court of Appeals opinion, even though we pointed out the court relied on later cases that have more to do with smartphones than what was available in 1997 with Guzman, is they followed Guzman to the T. They gave the trial court all the deference to which it was entitled and did a de novo review on top. Now, what you get then is, okay, if it's not plain view, is it consent? And he said the only reason I consented was my supervisor and the cop said, I got a warrant, you got to give me the phone. They gave him the phone. Well, consent comes later. You consent to search. Well, they still got the warrant, they already got the phone, and to presume that he knew that warrant was no good, that's not reasonable. So the trial court, the Court of Appeals have both found neither plain view nor consent gets them that phone. And without that phone, they can't get the report on what's in it, nor can the officer testify about what's in it.
So talk to me a little bit then about this idea that, the Fourth Amendment isn't about certainty, it's about probabilities. And I think what you've said is that by saying, is that your personal phone, it doesn't get you to the point of determining probability. And I'm curious about that. I mean, that's unlike you. I'm not as smart as you, or I'm not in the same kind of business as you.
I doubt
so
that.
I don't carry 2, 3, 4, 5 phones.
Right.
I just have the one.
Okay.
And it seems to me most folks, in my limited experience as a human in the world, generally have one phone. They're not carrying around
Yes.
all the phones that you have. So
I would agree.
yeah.
But there's a reason that the police ask their officers to provide their personal cell phone number. It's because, my opinion, I only guess this from everything that's going on, is they know most cops are carrying their own cell phone in addition to if there is a cell phone issued by the department, which several of the cops I know have 2 phones for that reason. They have their personal phone, whatever. But I guess the point is, she didn't know that it was his personal phone that he made the calls on. She knew it was the same number that the calls were made on. Now, it wouldn't be too hard for anyone in the court to figure out that my business number is 512-474-4747. And if you called that phone, right, it wouldn't be that phone, because that is forwarded to another number like many professions. But I think the point is, the Court of Appeals decided that this doesn't count as plain view because she did not have probable cause to believe that phone in his hand would contain evidence of the criminality she was investigating.
So she had called that number and the phone buzzed when it was in his hand? Then
Excellent.
You think we're there?
We've seen that in dozens of cop shows, right? Seriously, all they had to do was call the number. Maybe he's coming out with a cell phone, call his number. It rings, he sees it, this story doesn't happen,
But doesn't
we're
that
not here.
require us to decide that the Fourth Amendment requires certainty?
It does.
Certainty?
Just a level of certainty. And the level is that you probably will find evidence of criminality on that. Bear with me today, I had no power yesterday at all, and only to find out my laptop is dead because it was waiting on power to keep it charged. So I don't remember all the cases, and I didn't get to review this last night. One of the cases we talked about, federal case where they had a turntable for a record and turned it over. Yeah. Looked at the serial number, right? And that showed they couldn't use plain view because they had to get the serial number, right? That's the same thing that's going on here. Yes, if they copped the phone open and made the call, they made the call after they seized the phone, it would be problematic. But had they called, someone called the number that is listed as his personal cell phone and it rang, that's it. That's the end of the story. They can take it under plain view. It's right in his hand. It's ringing. We know it's the same number. None of that happened. So it's not that they're required to do that, but the point is the Fourth Amendment requires you, before you can rely on plain view, to believe probably this phone or whatever will reveal the evidence of the criminality we're investigating. And what I'd say is...
That's where I'm kind of confused because you're saying that, but I think what you mean to say at the end of that sentence is that to a level of certainty.
Yes.
Right? To a level of certainty you will probably find. And
No.
those two...
Yes, it is. You have to reasonably believe it, but the test is, will it probably have evidence of the criminality? And all she knew is he had a cell phone in his hand that he said was his personal phone, and she didn't ask, is that the phone you have listed with the police, or ring on it, or any other things? And it's not that she had to do that, but by not having done it means she didn't have the belief that was reasonable to think, well, there's going to be evidence of criminality on this particular device.
How would she have known which device to seize pursuant to the warrant?
With respect, Judge, I don't think that is the question. It's not what would she have to do, it's what did she do or what didn't she do. And the Court of Appeals found she didn't have the belief.
I mean, would you also argue that she did not have the authority to seize that phone pursuant to the warrant?
I think the warrant was no good on its face. And I mean, I agree with the state, and they took this position before that the Chapter 18 section doesn't apply. But I mean, we've got one statute that says to get into a phone, you have to do this. And yet you want to believe that to get into that same phone on a warrant by a JP, they don't have to know anything other than, well, he was in a crime and he had a phone. Because
What if it had stated probable cause? What if the warrant had been based on probable cause to seize that phone? Could she have seized it with the warrant?
That's a good question. What I'd say is, if it was a good warrant and the state hadn't abandoned it at the first hearing, I don't think we'd have the same conversation today. If she had a valid warrant, everything else becomes unnecessary. We have a warrant.
But wouldn't you still have the same problem of, well, how do we know that that's the personal phone that, you know, is associated with that number?
That question will remain. She had a warrant for any cell phone. The dissent below said they could seize any cell phone he had. I will not agree with that. it seems to me that,
So you would analogize this to, putting in terms of some other plain view. This isn't a situation where it's like, hey, these are golf clubs that were recently stolen from a country club because it has the country club insignia on it.
Right.
And so the minute you see the country club, you know that these are stolen. This is like, she knew that he had a phone.
Mm-hmm.
She didn't necessarily go, oh, well, this phone has a distinctive case, and now I see the same distinctive case in his hand.
every little bit that would add on to it.
She just knew that he had a phone.
Yes.
And she didn't have a visual ID of the phone.
Absolutely.
Okay.
But beyond that, I think the point is, you have to factor in, there's a reason the police want your personal cell phone number, and that's because they know most police are carrying 2 cell phones. Now, how can you say she wouldn't have known that? And if she did know that, maybe she needed to inquire further. But again, this is not a case about what you need to do, it's what did she do. I remember the day Guzman came down. I was a heavy-duty defense lawyer at that point, and I hated the case. But what I would say is that for the past 27 years, the courts have adhered to it. And we do look at things with the idea that if this court is right and the court that reviewed it is right, we don't reverse it unless it's clearly wrong. What I would say is the trial court who heard the witnesses and heard his story and heard Jackson's story believed that the seizure of the phone was no good, and from that, everything else flowed and it had to be suppressed. The Court of Appeals agreed. Unless this court can say those 2 courts were clearly wrong, this decision below should be affirmed. There are no other questions. Thank you very much for your time, and I'll take my 2 cell phones with me. I'd hate to have to replace them.
I would submit to this court if Mr. Schulman were a suspect and police believed that there were evidence on one of his 2 phones, that they could probably seize them both. And if they got approval from a judge, they could search them both. And they do not need the certainty of knowing exactly which phone contains the evidence as long as they meet that probable cause standard. And I think that manifests itself in many contexts outside of cell phones. I think in our society today, we get a little uptight about our cell phones because they do have a lot of personal information on them. That being said, imagine if this case involved a gun. There was a gun used in a crime, and some generic suspect has 2 guns. And they're not the exact same guns, but they're close enough, and the police haven't got ballistics back from the body, and they don't know exactly which gun was used at that point, but the police do see in plain view a person in possession of 2 guns. Maybe one's a revolver, one's a pistol. But they don't know, they just know that a handgun was used in the crime. I would submit that if they have probable cause to believe a crime occurred, and that if it's immediately apparent that one of those 2 guns is the murder weapon.
Guns are a little bit different though, right, because of the danger associated with them.
I don't think, the plain view doctrine doesn't have a danger element, Judge Newton.
No, it doesn't.
I would
But I would think that you would also have to say, oh, look, this is a gun, this guy's committed murder, maybe we need to seize it because it could be dangerous.
I can appreciate there may be additional exigencies.
Yes,
But
that's
under
what I'm trying to get
the plain view doctrine, as far as the evidentiary value, each gun has potential evidentiary value, and at the Fourth Amendment threshold of probable cause.
So you disagree with his assertion that you have to have a high degree of certainty to support plain view? Absolutely.
I believe that that's articulated best in the Supreme Court case Texas versus Brown or Brown versus Texas. The immediate apparent threshold is not a high degree of certainty. And I think with Hicks versus Arizona, which I believe was referred to, I think the issue there was by moving the stereo or moving the turntable, that constituted an additional search beyond the initial plain viewing. Also, think about a DNA sample. a lot of times you might have two suspects for one crime and you know you're only looking for one DNA profile, but for whatever reason you have probable cause to connect two different individuals to the same offense. You certainly wouldn't get a warrant for just one by flipping a coin. You'd probably approach a judge and ask for a warrant to be signed for each individual. You would take their buccal swab and you would compare it to the latent profile at the crime scene, and then you would know.
But didn't you concede that you didn't have probable cause on the first warrant?
Correct. The first warrant did not have probable cause, but our position is that Detective Jackson, at the time she took possession of the phone, that she had probable cause as a threshold. She just failed to put it in her warrant. And if I could get back to 180215, I do think this is a good case for this court to address this statute. I don't know that this court has addressed the extent to which this statute applies to the searches of cell phones in general, but I would urge this court, by its text, the legislature has restricted it to only those phones that are taken pursuant to an arrest. And I think there's good reason for that. When you arrest someone, you could arrest them for a municipal court warrant, you could arrest them for any number of offenses that have nothing to do with the cell phone they're carrying, yet in every case, police are inevitably going to come into custody with their personal belongings, including that phone. And it seems to me that what the legislature has done in the aftermath of Riley is they have codified an additional protection for arrestees who have their phones taken into police custody, that police must take additional steps before they search that phone.
And the applicability or non-applicability of that section would be a de novo review.
Correct. Statutory construction is a de novo question, Judge Newell. So that subject to line in 1802, that just means that any search, any warrant issued under 1802, which we're talking about the third warrant now by the district court judge, that power is subject to the restrictions of 180215, but 180215 by its text only applies to a subset of cell phones. So if a police officer develops probable cause prior to an arrest that a phone has evidence of a crime on it, and that phone is taken independent of the context of an arrest, that
Isn't there a difference between he has a phone that he has used and this is the phone he has used?
Correct. There is a difference. Are you referring?
No, just in this case. I mean, obviously in this case, right? I mean, there's a phone number. We're pretty sure it's his phone number, but that just because he has a phone number doesn't mean that this is the phone. I mean, you know, in Mr. Schulman's case, he's got at least 2 phones. Maybe somebody has 10 phones. Like, I mean, at some point, I mean, there has to. I mean, would you just describe like what level of certainty do you think we need to have to know that it, not just that he has a phone, but like this is the phone in his hand that he has used for this?
In this case, we have one phone number that appears in the police employee records, one phone number that is appeared in the investigation leading up to the seizure. He is holding one phone in his hand. At the probable cause level, I think it's more likely than not that when they download this phone, they're going to find evidence of the crime. And I think that easily satisfies the probable cause.
I know, but I guess how do you know? I mean, without us obviously going backwards and saying, well, we found evidence, so, I mean.
Oh, I want to be clear. Judge, I am not advocating for this court to use the evidence found as a way to justify the initial search. The Fourth Amendment does not tolerate that analysis, and I'm not advocating for that today.
Immediately apparent, though, is a different inquiry than probable cause?
Correct. You know, I think they're related. I think they're both based on reasonableness, but probable cause goes to, is a crime, has it occurred? The immediate apparent goes to the, as you're looking at the object, what is your reasonable belief as to whether or not there's going to be evidence contained within or on that object? So 180215, it simply is inapplicable to this case. And in regarding the third warrant, that seems to be the sole basis for the exclusion based on that warrant. I will acknowledge that there were some serial numbers that were taken from the phone that were put on that warrant. So those would, I guess, be redacted if there was a statutory violation, but in this case, there is no statutory violation because you would not have you would not have that additional protection because the phone was not taken into police custody pursuant to an arrest. If this court has no more questions, I will yield my last few minutes.
Thank you, Counselor.
Thank you.
The case is submitted.